2 and the motion adopted on February 25th, 2021, the committee is continuing its study on the subject matter of Bill C-15, an act respecting the United Nations Declaration on the Rights of Indigenous Peoples and to make related and consequential amendments to other acts. And a very brief comment, if I'm...
Just got muted, Mr. Chair.
All right, now. How's that? Can you hear me now?
Yeah, we can hear you fine.
Okay. So the artwork that you see behind me is a photo of a remarkable group of sculptures located near my often 13 Battle of Stony Creek. 4 9-foot-high granite eagle figures inscribed with symbols and text arranged on a circular plaza. The artist, David General, is Oneida, a member of the Six Nations of the Grand River, who works in a distinctive style using interpretations of the cultural traditions of the Haudenosaunee and Anishinaabe communities to address the theme of healing and reconciliation, and I am sure it will be in that spirit that we conduct the business before us. Now, members of the committee and witnesses, participants, please speak in the language of your choice. You can select the language at the bottom center of your screen in the globe where you will find English or French. And when speaking, ensure that your video is turned on and please speak slowly and clearly. When you are not speaking, your microphone should be on mute. And so we have our witnesses ready with Ms. Brenda Gunn, the professor at the Faculty of Law at the University of Manitoba, Chair Arnie Bellis, and research advisor Heather Exner-Pirot of the Indigenous Research Network. And I believe we've agreed that Thierry Rodin as an individual will be the third member of the opening panel. So Ms. Gunn, would you please go ahead for 6 minutes?
Hanshi, Brenda Gunn Nia, Winnipeg Niwikan, Mafimi, Red River Ochi. Hello, my name is Brenda Gunn. I live in Winnipeg and my family is from the Red River. I am Métis, and as noted by the chair, an associate professor at the University of Manitoba Faculty of Law. I work in both international and constitutional law, including the application of international human rights law in Canada for almost 20 years now. I've developed a handbook on implementing the UN Declaration, and I've done many presentations on the UN Declaration and how to begin implementing it domestically. Today, I am speaking from Treaty 1 territory and the homeland of the Métis Nation, my home territory. I want to acknowledge also the Algonquin people, as the House of Commons is located on unceded Algonquin territory. Thank you for the invitation to be here today. I am very grateful to be here, and I want to acknowledge my co-panelists as well. I will start by saying on March 22nd, 2018, I sat before this committee, invited to present on Bill C-262. As I prepared for my presentation today, I was wondering what I should say, thinking about what has changed and evolved over the past 3 years. And I kept returning to the same thought. It is devastating that we lost these 3 years. 3 years that could have been spent developing a national action plan, building on the work of the Truth and Reconciliation Commission and the National Inquiry. 3 years where Indigenous peoples have continued to have lower socioeconomic and health outcomes than other Canadians. 3 years is a long time. In fact, it's a lifetime to my daughter. I support this legislation because I think it is an important step toward reconciliation, toward recognizing inherent human rights, toward a fair and more just Canada for all. When speaking about the UN Declaration and why I believe it to be the framework for reconciliation, I often highlight 4 key preambular paragraphs that I'm going to read out to all of you now. The first is affirming that Indigenous peoples are equal to all other peoples, while recognizing the right of all peoples to be different, to consider themselves different, and to be respected as such. Secondly, the UN is concerned that Indigenous peoples have suffered from historic injustices as a result of inter alia, their colonization and dispossession of their lands, territories, and resources, thus preventing them from exercising, in particular, their right to development in their own needs and interests. The third is that the UN is convinced that the recognition of rights of Indigenous peoples in this declaration will enhance harmonious and cooperative relations between the state and Indigenous peoples based on principles of justice, democracy, respect for human rights, non-discrimination, and good faith. And fourth, finally, that the UN solemnly proclaims the following United Nations Declaration as a standard of achievement to be pursued in a spirit of partnership and mutual respect. What these four preambular paragraphs tell me is that in Canada, we need to stop believing in mythologies that recognizing the rights of Indigenous peoples is going to somehow tear Canada apart. We have to accept that we are broken, that Indigenous peoples have paid too high a price for the development of Canada for too long. We have to accept that the only way to reconcile is to recognize the rights of Indigenous peoples and shift from a colonial relationship to a relationship based on justice, democracy, respect for human rights, non-discrimination, and good faith. With this understanding of why we have a UN declaration and its significance in Canada, I want to just highlight one key aspect to the substantive rights included within the UN declaration. Specifically, I want to note that the UN declaration includes economic, social, and cultural rights in areas such as language rights, education, healthcare, housing, and economic development, all of which are critical to the exercise of civil and political rights. Under the international human rights system, there is no hierarchy of rights. Under Bill C-15, a national action plan that can be developed is critical to ensure that economic, social, and cultural rights receive the same level of attention and consideration as political and civil rights. During the prolonged debate over Bill C-262, there was unfortunate fear-mongering claiming that it introduced uncertainty, highlighting concerns around Indigenous people's right to free, prior, and informed consent, implying that Indigenous peoples might try to stop all resource development projects from proceeding. From my perspective, these so-called concerns highlight the need for a better grasp of the UN Declaration in Canada, the need for a coordinated effort to implement the UN Declaration into Canadian law in a way that builds upon the over 20 years of international human rights jurisprudence in which the UN Declaration is based. Canada was very slow turning its support towards the UN Declaration. There's a lot of work to do. We've lost a lot of time, and now is the time for action. While Bill C-15 is not going to resolve all problems and tensions between Indigenous peoples in Canada, it can be part of the solution. Bill C-15 includes some critical steps towards developing a plan to implement and realize Indigenous peoples' inherent rights. It includes important accountability measures to ensure Parliament puts words into action, and it addresses some of the misunderstandings of the application of the UN Declaration in Canada. Marcy, thank you, and I look forward to your questions.
Thank you very much, Professor Gunn. Next, we have Chair Arnie Bellis and Research Advisor Heather Exner-Pirot of the Indigenous Research Network. You have 6 minutes. Please go ahead. Mr. Bellis, still on mute. Ms. Pirot.
Arnie will be delivering the 6 minutes for us, so I'll wait till he's off of mute there.
Hello?
There we go. There we go, Arnie.
Okay,
Go-
thank you.
Go ahead.
Well, thanks for allowing us to present to the standing committee. My name is Arnie Bellis. My Haida name is Gwagwonkin. I'm a member of the Stostis clan in the Haida Nation. There's a lot to speak to, and the young lady before me did a very good job of summarizing sort of the history of Canada and its relationship with First Nations. And I tend to look towards the Canadian Constitution and that we fought for in the World Wars. And it talks about multiculturalism and rights and all those wonderful things that we live under. But, I find it interesting that First Nations people had to go to the Supreme Court numerous times to have those rights upheld and worked on. But I'll let the statistics of the land speak for themselves, in terms of the employment and all the incarceration and so on, and they speak for themselves. But we used the resources for 10,000 plus years, and from there we developed a very sophisticated society, and we found ourselves under the Indian Act and people moving hard to move us through their line of thinking in terms of the religion and move us off our mythology. So in saying that, to a certain extent, our intellect was stunted, and now we're back on track, and we're looking to use our resources to enhance those things as culture and mythology. And under the Constitution of Canada, we're allowed to do that. The Haida people, as one, we went down to 580 people from 12,000 plus because of smallpox. But yet we're still trying to define a relationship with Canada where all could benefit, and it works both ways. Our organization is, the IRN is, we developed this to speak for the working people of First Nations. We're a nonpartisan group. We're a young organization, but we've seen the need to participate in this discussion to try to evolve that relationship between First Nations and Canada and industry too. And I have an extensive background with working with industry and coming to some really positive situation that provides solutions for both parties. I been studying Bill C-15 and participated in a number of roundtables and consultations and Zoom conferencing, and our members have done the same. And Heather will add more detail to that. And part of it is the economic development, and that's one wedge of the pie. There's other wedges too that have to be addressed, as I talked about, the environment, the culture, and things of that nature. But we also realize that other things exist in this world, and one of them is investors. And in order to stand up more and things of that nature, we have to have investors, and First Nations are not exempt from that. But we like to attract investors, but not kind of give away the farm, so to speak. But also we fully understand that we need that mechanism. So in saying that, I'll get right to it. The action plan we'd like to participate in, and I think we could have a really good, clear conversation on how to make that enhance the relationship in a stronger way, and to come to a place after understanding each other's more, and there is understanding between First Nations and Canada today, but that's evolving on a daily basis. And so with that, in talking to a friend in the BC Business Council, the UNDRIP situation is already starting to cost investors a bit, and we need to concern ourselves with that if we want to make ourselves a viable group to invest in. So with that, Mr. Chair, I'd like to thank you again. And I'd like to thank Romeo Saganash and the individuals that brought this to fruition so that we could speak to it. And I have some friends that went to the UNN for a lot of years, and took time out of their lives to evolve this. And I'd like to say hello to them and thank them very much for, their sacrifice and their away from their families. So I'd like to acknowledge that. Thanks,
Mr. Bellis. We're over the allotted time.
Okay.
I'm sure anything further will come up through questions. And if anything is not covered that needs to be covered, we will take written submissions for some time afterward. So if you feel that something has been missed, please take that opportunity. And Thierry Rodin for 6 minutes. Please go ahead.
Good morning, everyone. As I've already said, but I want to add my thanks to this standing committee for inviting me here. I'm a professor of political science at Laval University, but I work more specifically on Indigenous issues in Canada in particular. It is in this vein that I will make my remarks to you. And I also have a research project on Indigenous works in Canada and New Caledonia and elsewhere that deals with the informed consent, that is to say, free, prior, and informed consent, and how that is being respected in Indigenous communities. I'm familiar with these issues, but I'm also interested in the issues that are at play, particularly in Canada. I think that there's a matter of uncertainty here, and that is rather widespread. I can say that what has happened in Canada has been an extension, perhaps, of the colonial attitude since 1867, with the passage of the Indian Act, as it was known at the time. And the relation between Canada and the First Nations was of a peculiar nature then. And I think that I am certainly in favor of C-15 because this can lead to change. But unfortunately, it's mostly symbolical. I can say that most legislation is imperfect in and of itself, but I do believe that it is a good step. It is a piece of legislation which will address the relationship with the First Nations and will find solutions. It is a bill that it will be part of the reconciliation process. We all saw in May the intervention by the RCMP when it intervened with a group of Tsawwassen First Nations people. So I believe that this bill, though, the scope of the bill should be broadened, but nonetheless, it is a good thing. The scope should be broadened to take into account the major Aboriginal groups. Let me now come back to the question of uncertainty, because this is an issue that has been much talked about in terms of comments made about the legislation. Uncertainty is not going to be created by this piece of legislation. It's something that exists in Canada. This is in a sense, a standalone bill that will not be problematic, but it could lead to some tensions. You know that there has been some difficulty already in terms of the Superior Court of Alberta's ruling and Coastal GasLink, that issue, is what involved the group of Wet'suwet'en. But there is another case that is perhaps less well known. In Nunavut, there is a mine that is being operated, and that is being its operation is being threatened. So we've seen that even if there are processes that are in place, and there were specific processes in Nunavut that were in place for approval of the project, but nonetheless, which involved consultation and which involved informed consent, but nonetheless, there are these procedures in place that are supposed to lead to the informed consent. But that didn't happen because the Inuit community opposed the operation and blocked the airport, shut down the airport. We don't know yet how one will be able to obtain free, prior, and informed consent. You'll have to take into account all kinds of variables and what is understood by the people. There may well be conflict, but we want to have a very clear way of acting on these issues, but that may give rise to difficulties. We can, in terms of the economy, look at this legislation and see what the repercussions will be. And in the research that I have done on Indigenous people, for the moment, they and Romeo can speak to this a little later on with respect to the situation for the Cree and how it unfolded. But there could be difficulties, there could be crises, there could be blockades, there could be airports that are being shut down in the future. Well, if C-15's intent is to mitigate the uncertainty, and we hope that it will be successful. In my research, I hope to be able to provide some enlightenment to the committee, and I'm going to finish by saying we know what consent is. That's not the problem. But when it becomes more complex is how to get to that consent, that informed consent, under the terms of the context of Canadian law, and also who should consent? Who should be consenting? And this is a problem that involves the colonial relations government of Canada and the Aboriginal communities. I thank you for your attention.
And let's go right to questioners now. And I have Mr. Schmale, Mr. Batiste, Ms. Gill, and Ms. Gazan or Ms. Blaney. Ms. Blaney will be the speaker. 6 minutes to begin with. Mr. Schmale, go ahead.
Thank you very much, Chair, and good morning to our witnesses. Lots of great testimony today, and I just want to start off by saying that we here on this side of the aisle do support the spirit of UNDRIP. There are a lot of good parts to it that I think will take us on the path to reconciliation and to have that important and meaningful conversation. as many of you know, the issue we have with it, as some of you have said in your testimony, is with FPIC, the C, the consent, and what that actually means. Maybe I'll start with the IRN, if we could. Looking on your website, your organization knows that there are already barriers that exist to attracting investment to your lands and to your people, and that C-15, without a proper definition, could add yet another barrier and potentially take away that idea of investment in jobs and opportunity in some of your communities. Did you want to comment on that?
Maybe, Arnie, I'll jump in first and then you can follow up on me. So pleasure to be here. My name's Heather Exner-Pro and I serve as a research advisor for the IRN. So to answer your question, yes, as already mentioned, we've been doing our research on C-15. We have some close relationships with some members of industry. We've reached out to mining, to oil and gas, to hydroelectricity, to railroads, to some investors, pension funds, private funds. We've also spoke closely with our colleagues at the Indian Resource Council, FNLNG Alliance, and the First Nations Major Projects Coalition to get a sense of what are the implications, what are the practical implications of C-15. And there's a lot of concern, and you don't have to take my word for it, and I encourage you to, talk to the investors yourselves. But if our particular principle is that First Nations people, Indigenous peoples deserve economic development, that resource development is almost certainly the best opportunity to get that, then certainly we want to have an environment in Canada where resource development can happen. And in speaking to all these people, yes, there was a sense that Canada is not a good place to invest, that there is some risk. C-15 is one more thing that adds to risk because it isn't clear what consent requires. Is it a BCR? Is it a referendum? Who is a representative institution? Is it hereditary chiefs? Is it band council? Is it any member of a nation? All these things just make it riskier for capital. And so we did hear that, it's very difficult to invest on Indigenous territory because it's very risky. I think you're all aware that Indigenous peoples have been getting more involved, especially since the duty to consult decision in 2004, 2005. They've moved from being, employees to contractors to now becoming equity owners themselves. When they've been going out to try to attract equity, and that is the future, there is a risk premium for Indigenous nations to attract capital, to do their own resource projects, to be their own proponents, and to attract that equity. And as Arnie mentioned, talking to the BC Business Council to see what had been the implications of their Bill 41, that yes, they said there's been 1%. That's the number they said. That there's a 1% risk premium attached to BC resource projects since that bill itself passed. So where I'm coming from, personally and professionally, wanting to see Indigenous people being able to benefit fully in resource development, understanding there's a commodities boom coming and that we're kind of coming out of COVID-19. If we add 3 years of uncertainty as we develop an action plan to the ability of investors to want to invest in Indigenous territories when Indigenous people want it themselves, then I think tens of billions of dollars are at stake in their development. I honestly do.
Yeah, I don't know if you want to add more, but I guess that, we all heard the debate in the House of Commons, and the government in its own words claims C-15 does not provide a veto, yet they refuse to actually define what actually consent is. And to your comments, the concerns and uncertainty, and you're right, if you add even a 1% risk factor to some investment, there are many places investors can take their money and resource projects, and it doesn't necessarily have to be resource projects. I think it's almost anything. Adding that uncertainty does hurt the economic reconciliation that I think needs to happen as well.
I haven't spoken to a single Indigenous person who doesn't support UNDRIP and the principles of UNDRIP, and they're very cautious in coming out and saying, I don't want UNDRIP legislation because that's not the sense. We don't have to throw the baby out with the bathwater. I think this legislation could be amended so that it provides that, that clarity, that certainty to investors, that allows for investment in Indigenous territory without, giving up all the rest of the rights and the ways that they can be applied to improve many other aspects of Indigenous people's well-being. So there's, I think there's some amendments. I think, we're not lawyers. Our members are not lawyers. But I guess that's your job, is to figure out how can you write this legislation so it doesn't deter billions of dollars in investment And if you talk to investors and industry, they will tell you that this is going to cost, that this will cause capital to flee. It will not make Canada an attractive place for investment.
And that's, that's exactly our position. You said it more eloquently than I, so thank you for that. But it's basically what we've been trying to say is we support, like, don't throw the baby with the bathwater, as you said. There are lots of good parts to this document and the path, but there's a major part that we're having a problem. And as you said, it's our job as legislators to do our work and create this so that there isn't more uncertainty or it gets fought in the courts for years and does maybe perhaps increase that 1% risk factor to 2 or 3%, which would almost dry up any opportunities.
Mm-hmm. And there's lots of things.
We're right at time for there. Thank you very much. Could I just ask Madam Berube, Madam Gill, was the translation okay? I was going back and forth and it was a bit confusing on the French. So are we okay with the translation? Thank you. Okay. And now we'll move on to Mr. Baptiste for 6 minutes.
Thank you, Mr. Chair. On September 12th, 2007, more than 143 countries endorsed the Human Rights Council's recommendation to extend human rights and fundamental freedoms with UNDRIP. And I just find it simply amazing that the most vulnerable bottom of global humanity was able to find so many allies within the United Nations. Ms. Gunn, I know that you've got a long experience of going to the United Nations yourself and establishing the UNDRIP handbook and creating awareness around them. Can you speak to what is the significance of UNDRIP, and has any of the issues been raised around the economic catastrophes that people continue to speak in these 143 other countries that decided to give Indigenous people the minimum human rights in the world?
Thanks, Mr. Baptiste, for your question. I will try my best to answer it. If I may, I'm going to do it somewhat laterally and perhaps respond to the trends that I see happening internationally. And so I think it's really important for this committee and for our parliament to be aware that internationally there is growing acceptance of the obligations of businesses and companies to uphold human rights. And that internationally, right now, there are negotiations for a binding treaty on the obligations of businesses to respect human rights. So when we talk about implementing the UN Declaration, and which includes the right of Indigenous peoples to free, prior, and informed consent in certain circumstances, this is becoming very standard internationally. And I would hope that Canada, as a country that holds itself out as a leader in human rights, is going to continue to positively participate in arenas where human rights are being pushed. And so even where we continue to sort of sound these alarms at home, they're not being sounded internationally. In fact, even the World Bank, in their environmental and social framework for IPF operations, ESS 7 on Indigenous peoples, includes free, prior, and informed consent as one of the requirements for World Bank funding. Right. So this, I mean, maybe investors are saying they're concerned, but I can tell you internationally, the expectation is that industry is going to uphold fundamental human rights. And the UN Declaration is just one place we can turn to understand the rights of Indigenous peoples. But also, as I alluded to in my introductory statement, the UN Declaration is not the only instrument out there that's relevant. It is very clear under other binding international human rights treaties that Canada is a party. Indigenous peoples have a right to free, prior, and informed consent. This includes the International Covenant on Civil and Political Rights and the International Convention on the Elimination of All Forms of Racial Discrimination. And so while, of course, we all want to be aware of economic impacts, we also have to recognize that right now there are many Indigenous peoples who are paying the price for development. So maybe we're talking about shifting some of the economic costs and benefits of But I don't see Canada being offside by this consideration in the bill here, that we are actually apace now with these international developments. And if this doesn't happen, it's coming in elsewhere. So we might as well work now to start making sure that our domestic processes are upholding these international standards.
Thank you, Brenda. And in my research of UNDRIP, it talks about this was developed over 30 years by thousands of Indigenous people across this globe. And I'm wondering, when you created the handbook, on UNDRIP handbook, you began doing sessions all across Canada. I know one we coordinated together in Halifax. Can you speak to what's the consensus that you've heard from Indigenous academics and Indigenous people on UNDRIP, and what their thoughts were at these sessions that you held?
I can say that from my experience participating internationally, that many Indigenous peoples turned to the international arena when there were challenges that they were facing domestically and could not find sufficient resolution. And so what I have seen and what I have heard, and even what I continue to hear today when I hear people speaking about Bill C-15, is that it's time to recognize these basic, fundamental, inherent rights of Indigenous peoples. We can't keep treating Indigenous peoples as lesser peoples, right? That's why I read out that preambular paragraph. Like, it's really time for Canada to recognize Indigenous peoples as peoples, right? There's too much of Canadian law that is based on these racist ideas of, in Johnson and McIntosh back in 1823, that Indigenous peoples are fierce savages whose occupation is war, right? It really should be now in 2021, a time where we start rejecting those ideas and work with Indigenous peoples to realize these fundamental human rights. And I think importantly, this bill has a lot of wisdom in that it's not just saying, okay, we're accepting UNDRIP, but it's actually forcing us to come to the table, sit down, and come up with a plan to implement it. So these concerns that are being raised, the National Action Plan is the time and place to hash out some of these questions, right? So it has built in the bill itself, in the legislation, a way to address these concerns, and not just sort of we're concerned that there might be impacts, but to study and come up with a plan that ensures that Indigenous peoples and Canadians benefit from development.
Thank you very much. Et maintenant, Madame Gill, vous avez la parole. 6 minutes.
Merci, Monsieur le Président. J'aimerais remercier l'ensemble des témoins qui sont avec nous aujourd'hui et saluer, je sais que Monsieur...
I'd like to thank the witnesses who are with us today. I know that Mr. Saganash hasn't been able to get here, but I know how much he has struggled to deal with this issue. It's so very important, the way that we are working today. And I also know the contribution that's been made by the First Nations over the course of centuries, who have led to this bill finally being presented. I hope that we will be able with it to move from what is symbolic to something concrete, to something that is tangible. I have a question for Professor Rodon, who I know in the most recent review of Amerindians in Quebec published a variety of texts, several of them, about free, prior, and informed consent. I'd like to know if he could say a few words, perhaps expand on the notion that he was dealing with in the publication. Thank you very much, Ms. Gill. Yes, I published a special issue of the Amerindian research in Quebec, scholarly publication, and the idea came about because we wanted to be able to put how we could put into practice and not just be satisfied with declarations and legislation. What could we put into practice? I didn't have the time to speak to this in my presentation, but there are rights that exist and that are considered to belong to certain peoples. This right to free, prior, and informed consent exists. You see it everywhere, and the Cree are very aware of it, even though it wasn't expressed in that way. But for the Cree, it was very clear that, and when you interview them, that particularly those in the area of Abitibi, that in the northern part of Quebec, they say very clearly, if the Cree don't want a project, it isn't going to happen. And it's not from the political perspective here. The people in the north of Quebec will decide whether or not, yes or no, there would be a project. It might benefit the community, or it might not be of benefit to the community. But there are other cases, of course, where there is more conflict. And we've seen that over some years. I think that it is to the honor of those people who have been able to defend their territory. So what happens is this: if you think of the Wet'suwet'en, and if you think of the Inuit communities in the north, they have a general agreement, and they block the roads. They put up blockades, and they block the roads and the airports. I think Ms. Gaber had a very good point about this, because this is what is happening on the ground. There is a bill in Quebec, or rather there is a project in Quebec, a gas pipeline that would be going towards the north as well. And here you're looking at an area where you would need tools to settle any issues. So whether or not you can implement this free, prior, and informed consent or not is something that we will see. But you have to recognize Indigenous rights. It's not by ignoring Indigenous rights that you will have fewer problems. Quite the contrary. We have seen cases that were centered on Quebec, because that's where I look, but elsewhere as well. So if you look at it subject by subject, you will see that this is the way to go. Thank you so much, Mr. Rodon. I will have some questions, though, for you, because at the end of your presentation, you said that there were issues that could arise, questions that could arise with respect to prior and informed consent. As to its definition, that's where the problem lies. How do you define it? But you gave us the outlines of the problem. You spoke of the camp, and so who should be giving this free, prior, and informed consent that our witness earlier spoke to? This gives rise to many questions. Well, as to free, prior, and informed consent, there is a tension that exists. In terms of the procedural version, you have to look at consent. You have to take action that has to lead to consent, but does not cause issues does not harm anyone. This is the instance in Canada, but there is also a more substantive consent where a community gives its clear consent on an issue. When you have communities like that with the mining company that I mentioned earlier, and the gas pipeline, that's another example. But perhaps the most difficult element of all this is who gives consent. I'm looking at that in research, and this is something that has to be resolved within the structure of governance. In Canada, you have a structure of governance that the Indigenous people have been given to themselves. But in the case of the Wet'suwet'en, there was this remnant of the colonial rule, and traditional governments are still there.
We're over time on that. Perhaps it'll reprise in a later conversation. Right now, I believe Ms. Gazan is going to speak now for the NDP. Leah?
Yes, thank you, Mr. Chair. My first question is for Madame Exner-Perot. Did I pronounce your last name right? Okay, thank you. I'm always worried I'm going to pronounce last names wrong. You spoke about 3 years of uncertainty because that's the maximum time provided for Bill C-15. And you claim that it comes with a cost for investors. I'd like you to comment on risk disclosure in international trade rules, especially in relation to land claims. In this country, areas that are still under dispute, referring specifically to land claims, aren't we negotiating international trade deals then on a lie?
I wish I could answer your question. I'm not an investment expert, but I will just say that I think the action plan is an excellent vehicle. That that if and Ms. Gunn, Dr. Gunn mentioned this too. I think lots of people would be happy if we could focus on the action plan, make the legislation follow on the action plan.
Just because I have a very limited amount of time, the reason I ask that is because we know that risk disclosure is a warning you must provide investors any investment in terms of following law. So I just wanted clarification on that. My next question is for Ms. Gunn. The 1982 Constitution of Canada recognizes and affirms Aboriginal and treaty rights, which is a general concept and has a level of ambiguity, and we know that. This has been a constant issues in defining the concept of Aboriginal rights. Do you think that Bill C-15, which affirms the application of UNDRIP in Canada, will lessen this ambiguity?
Thanks, Ms. Gasm, for your question. I'm going to try to answer it as quick as I can. There was included in the original Constitution the idea to try to negotiate additional understandings of Section 35 through those constitutional roundtables that were going to look at self-government, and those didn't succeed. And so we've had the very unfortunate situation in Canada where a broad general phrase of Aboriginal and treaty rights is what is protected in the Constitution. And with unsuccessful negotiations, you're right, it was left to the courts to determine. And we continue to have litigation over defining the scope of these rights and some negotiations as well. I do think that Bill C-15 and the UN Declaration provide some useful supports because it helps flesh out that general understanding, like what are Aboriginal treaty rights? There's a whole list of rights that are included with the UN Declaration that help us understand. And I would just say, importantly, from my perspective, is that the inclusion of economic, social, and cultural rights, as well as civil and political rights, is really important, particularly when we think of Indigenous women. And I think the National Inquiry, as well as the BC Inquiry into Murder and Missing Indigenous Women, highlight the way in which economic, social, and cultural rights are particularly important for Indigenous women and to ensure that equality. And we haven't seen as much success in litigating economic and social cultural rights in either the Constitution or the Charter. So I do think there's a lot of clarity that can be gained through Bill C-15.
Excellent. Thank you so much. My next question is for Mr. Rudon. Much of the concerns that are raised are around FPEC. I'm wondering if you could share with the committee your understanding of FPEC versus veto.
Oui, c'est une question qui.
Yes, that is a question that arises. Well, I think that my opinion is this. Well, politically, we want to defuse this question. I don't think that the Indigenous people are looking for a veto in terms of relations. Clearly, the right to say no is part of the relationship in a discussion, but there are instances where you say no. It's part of the relationship, And in that relationship, you have the two actors that are involved, and it is up to these parties to find a solution. For example, the aluminum instance in Cree territory, the Mississippi. Well, it's not a veto. If you think in terms of veto, you're thinking in terms of a relationship of force, of strength. But you have to move away from that type of rationale, that way of thinking. Can there be, at the end of a process, the possibility of obtaining consent through in the third world? But you can't really talk about veto, because a veto that really has to be set aside from the beginning. I think this is how we have to address it. And that is what is going to allow you to untangle this web. There are some very simple ways of obtaining consent with Indigenous peoples in terms of the projects by discussing them.
Oh, I just want one follow-up question.
Well, we're at time right now,
oh,
Ms. Gazan.
okay.
I'm sorry.
Evans, thank you, Chair.
Yeah, I know. And time, I'm going to ask Mr. Schmale and Mr. Ananda Sangari, we're at time now. We could suspend and start, arrange the next panel and hopefully get to Mr. Saganash as well as our other guests. Or we could continue on with the second round. So do you have any preference? We will extend the meeting as needed on a motion to extend later on. But what's your feeling right now?
Mr. Chair, my sense is if we are willing to extend by, say, half an hour, then I suggest we do a second round, maybe a shorter round of maybe 3 minutes each of the Conservatives and Liberals, and then maybe a minute and a half to the NDP and the Bloc, and then switch over.
Okay, are you good with that, Mr. Schmale?
That works for me.
Okay, Madam Beyrube, Ms. Gazan, everybody? Okay, so we'll continue on now. Mr. Vidal, you're up, and we'll have 3 minutes for this round.
Thank you, Mr. Chair. I guess I'll have to just hustle up and get right into my questions then, We've heard a number of people reference the action plan today, so I want to go to Ms. Exner-Perot and just quickly ask the following question. My understanding of the bill as it is now requires an action plan, as did Bill C-262, but the bill does not require the action plan to include any targets and/or deliverables. Professor Gunn, in her comments earlier, referenced a lost 3 years on the action plan since 2018, and she also talked about, that's the time and place to sort out many of the issues. To me, it looks like maybe New Zealand has figured this out, where they're doing the heavy lifting and putting their action plan in place before they implement the legislation. And so my question to Ms. Exner-Perot is, could you maybe explain from your organization's perspective what the value of putting the action plan before the legislation might be in addressing some of the uncertainty that you talked about in your investors?
Yeah, so not just investors, but also, other Indigenous organizations interested in resource development don't want that uncertainty. And in the general consensus from the people that we've been able to talk to is that the action plan would be, a great vehicle. We have lots of ideas on things, concrete that can make it easier for Indigenous people to attract capital, putting the eye into ESG standards, procurement, things like that. So, and I know our partners do too. So the more that I think the legislation makes clear that the action plan will fully articulate, there's a status quo until the action plan is agreed to, I think the better, then you can have the consultation. I know there's lots of concern that there hasn't been enough time, that this feels rushed. And I think if there's an understanding that the action plan is the place where we can decide what's going to be different, what's going to change, what's going to be the practical implications of C-15, that would take care of a lot of people's concerns. And I'm sure if you speak to other people in industry or pension plans, they might say the same thing. But certainly from the perspective of our Indigenous organizations we're working with, they have lots of ideas in the action plan and prefer to see that the vehicle.
1 minute, go ahead.
Thank you. I'll be really quick. Professor Gunn, maybe just would you comment as well? You made the reference to having lost 3 years. Would there, in all of this process, would there have been anything preventing the government from starting the action plan so that by the time we got to this point 3 years down the road, the legislation would have a lot more certainty and clarity?
Thanks. I think practically, you're in a better position to know how government works than perhaps I am. And there was nothing, but there was, of course, challenges that we see. We had all put in a lot of time and effort into Bill C-262, and it had made it through the House, and it had made it through many steps of the Senate as well. So I think we had all anticipated it successfully entering into law, and we all had to shift gears when it was quickly died in the Senate. And so I think reformulating an approach after that happened took time. But I think importantly, the reason why we can't just do an action plan first is that the UN Declaration, under rules in Canadian law, does have relevance already and is being used by the courts. And I think we want to, as much as possible, to have a coordinated approach. And while it's important for the UN Declaration to be able to be used in litigation where necessary, we don't want to rely on that. So I think I would flip the question to say, if we don't move and clarify this recognition of the application in Canadian law, we're leaving it to the courts to have that interpretation. And it leads to more uncertainties and irregularities, for example, between the provincial courts and sometimes what we're seeing in the federal courts.
Thank you for that. And thanks for trying to work to the time limits that we have. Mr. Van Couverden for 3 minutes.
Thank you very much, Mr. Chair, and thank you to all the witnesses. This has been extremely helpful for all of us. And thank you to many of you for your considerable work on this subject. To be totally honest, many of us are coming into this with fresh eyes, and your years of work and considerable effort on this are really, really helpful. I have a question for Professor Gunn first, and it does come back to free, prior, and informed consent as a veto. I think, the word veto has a definition, and perhaps free, prior, and informed consent might be a little bit more ambiguous, but I'm really concerned with the conflation of those two. And I would love a little bit more insight on that. And since I'll probably just ask one question, if you could sort of provide a little bit of insight on participation and the ability to say no. I believe that participation includes the ability of full participation includes the ability to say no. Thank you.
Thanks. I think it's really important to remember again that the UN Declaration didn't just pop out of nowhere. This goes back to Member Baptiste's question. There's actually 20 years of jurisprudence and studies that have happened at the UN Declaration, at the international level, that help us understand the UN Declaration. So while we say in Canada we don't know it, it's only because we haven't looked. And I'm happy to provide this committee with various studies that have happened that have really fleshed out, and I can provide decisions on, how the UN is understanding free, prior, and informed consent. But we focus a lot on consent, and consent is really is included to ensure that Indigenous peoples who have a really good understanding of their rights are involved in decision-making where their rights are specifically and especially impacted. And so I think you're absolutely right to connect free, prior, and informed consent to the right of Indigenous peoples to participate in decision-making. And the idea internationally is that Indigenous peoples' inclusion, including gaining their free, prior, and informed consent, helps us to make better decisions, ones that are going to stand. I think, finally, this idea of a veto or not veto sort of suggests that we're not having a conversation. And this is where it's important to remember that we also have free, prior, and informed, right? The whole idea when you use those four concepts together are about making sure that Indigenous peoples are there, are engaged in the process, and can provide the necessary information, and that there is this idea of a back and forth, a conversation where we can understand the concerns that might be addressed, have opportunities to try to address them, and work together to come to a resolution. That's the understanding of the package of free, prior, and informed consent.
And that only leaves 30 seconds, so thank you for that. Mr. Van Couverden?
I'll give it back to the chair, just considering that we're on a tight schedule. Thank you very much. Marcy, Professor Gunn.
Thank you. Madam Bérubé, a minute and a half.
Thank you very much, Chair. And thank you to the witnesses that are with us today. I represent Abitibi, Bay James Kuyu, and it was mentioned earlier. Mr. Rodon, you talked about certain countries that have adopted UNDRIP. Can you tell me, to your mind, what are the difficulties that came with implementing the declaration? To my mind, or at least to my knowledge, I don't think that there has not yet been a country that has implemented it. And included, except for Colombia in South America, that has chosen to have a procedural implementation. It's a process, only just a process, and the process has to be respected. But once the process is respected, the project can advance. And so that's really the procedural vision of free, prior, and informed consent. With respect to this, what we are defending is somewhat different, is a more substantive vision. If as Madame Gunn said, it's a conversation that has to be maintained. The example of the Cree is a good one. The policy that led to the Cree situation was that, well, the mining company can bring up a project, we'll discuss with them, and we will decide what is good for the community. This is something that is beneficial for everyone when you proceed in that way. Some projects have been mounted, have been brought about, but have really led to nothing. And here in Canada, we want to have a clear process which makes it very clear who should give consent, how it should be given. It's not a matter of the government or the governments deciding. It should also be the impacted community.
Ms. Gazan, your turn for a minute and a half.
Yes, thank you. My last question is for Mr. Rudon. I had asked you a question about FPIC. Do you believe that having more clarity with this bill will help keep projects out of courts? I say this because we know certainly Madame Exner-Perot is concerned about that, but do you think the lack of clarity and the clarity that this bill will provide will help improve relationships and also projects going forward?
Yes. Yes, that's what I say. I think there should be a process that is clearer, that takes into account the relationship between the interveners, between the stakeholders. Not just the courts. I mean, we talk about the courts, but there are also other instances where there can be, blockades and so on, and where, say, the RCMP would have to intervene, and there can be international repercussions. So I think it's a lose-lose situation when this type of thing starts happening. And if there is more clarity, it will help the situation. It will provide a climate that is beneficial for investors as well. The fact that they are able to say, okay, we invest here, and that there won't be any problems. It's a vision that is somewhat narrow to think that Indigenous people decisions will not be tangible. It couldn't be worse if you thought that way. Is it one way that you have to think is that there will be an effect?
Mr. Melillo, 3 minutes, please.
Thank you, Mr. Chair. I wasn't sure if I was going to get some time, so I appreciate that opportunity. Maybe I'll just ask for sort of pick up on some of the topics that have already been discussed, but just to flesh them out a little bit more. And obviously there's been a lot of discussion on around consent and on the importance of that free, prior and informed consent, what that means to different people. And maybe I'll just go to Ms. Gunn first. If you could just maybe touch on that a little bit more. Obviously there's a lot of differing opinions depending on who you talk to. You mentioned the UN has done some work on trying to provide some clarity on that. Can you just maybe speak more to that?
Sure, I'm happy to continue the conversation. I think starting back in the early 2000s, the Permanent Forum on Indigenous Issues had a study on free, prior, and informed consent that set out a lot of the standards about what sort of information, what does free mean, what are we talking about prior and consent. And I think this was then followed up with the study by the Expert Mechanism on the Rights of Indigenous Peoples in 2018, when they studied a human rights-based approach to free, prior, and informed consent. And on this idea of a veto, they clarify that free, prior, and informed consent is really about, again, protecting the rights that we're recognizing broadly in the UN Declaration. And so when we talk about consent, the expert mechanism does state that there are circumstances, and they're set out in the UN Declaration, when states are obligated to get Indigenous peoples free, prior, and informed consent, and that the element of consent, they say, includes that idea that Indigenous peoples do have a right to say no, that they may withhold consent following an assessment and conclusion that the proposal is not in their best interests, that withholding consent is expected to convince the other party not to take the risk of proceeding with a proposal, and that this is not. And the expert mechanism has said arguments of whether Indigenous peoples have a veto in this regard appear largely to detract from and undermine the legitimacy of the free, prior, and informed concept. And so we're really about including Indigenous peoples in the process to ensure that we're upholding rights or understanding how their rights may be impacted by various projects.
Thank you very much. Thanks, Mr. Melillo. And Ms. Zan, you'll close off our session with 3 minutes. So please go ahead.
Thank you so much, Chair, and thank you so much to the witnesses. As I said, I come to you today from Nova Scotia, from the unceded territory of the Mi'kmaq. I would just like to ask Ms. Gunn, please, regarding the specific Truth and Reconciliation Commission calls for action, which call on governments to fully adopt and implement UNDRIP and develop an action plan to achieve its goals. It is also referenced throughout the calls of action that it is reference to the final report of the National Inquiry into Missing and Murdered Women and Girls. So could you please expand on why you think that the Truth and Reconciliation Commission and National Inquiry both emphasized that the declaration is such a key part of reconciliation, and offer your views as to why this international document is so essential to advancing reconciliation here in Canada, and in particular with the missing and murdered women and girls? Thank you.
Thank you, Member. I will try to do so quickly. I was trying to allude to this in my opening statement, but I'll try to be more concrete here. I think the Truth and Reconciliation Commission focused on the UN Declaration as the framework for reconciliation because it simultaneously recognizes that where states are basing their laws and jurisdiction off racist ideas and laws such as the doctrine of discovery that are based in the idea that Indigenous peoples, as I said, were fierce savages whose occupation were war, was sort of used as the justification to undermine fundamental rights. And so the UN has said we have to start really addressing those questions, but also really importantly, that through the process of recognizing Indigenous peoples inherent and fundamental human rights, we begin to shift the relationship from a colonial one where a state thinks that they are, with their paternalistic approach that we see sometimes in Canadian law, that they have all the power over Indigenous peoples, that by recognizing Indigenous peoples' rights as articulated in the UN Declaration is going to help us shift a relationship and enhance harmonious relationships. And it gives us new grounds for the relationship, right? So it says it's talking about a relationship based on the principles of justice, democracy, respect for human rights, non-discrimination, and good faith. Not just about colonial domination, which may have been the basis of the relationship historically, but actually trying to reset that relationship and uphold these fundamental principles. And I think...
And we're right at time there, and so I'm sorry to interrupt.
Can I just beg to address the Indigenous Women's Inquiry? Can I
go
beg
ahead,
that? I just want to say that from my perspective, the importance of the UN Declaration is the recognition of economic, social, and cultural rights. So things like housing, things like education, things like the rights to a job, those are issues that have been recognized by the inquiry as fundamental for protecting Indigenous women.
Thank you so much. Thank you so much, members of the panel. We are going to suspend very briefly. We have to do some sound checks with the next panel. So, and we'll be very quickly back to resume. So this meeting is now briefly suspended. And we will continue with our second panel, including Mr. Saganash, Ms. Lightfoot, and Ms. Augustine in that order. And Mr. Saganash, I understand that you have a little bit of knowledge about this topic, so I'm going to give you the honor of starting off. Please go ahead for 6 minutes.
Unmute.
Mute, yeah.
Here, is it good?
Good.
All right. Well, thank you, Mr. Chair, and good morning, and good morning to other committee members. Thank you for the invitation to appear to this committee and make some opening remarks before we go into questions. To date, the United Nations Declaration on the Rights of Indigenous Peoples has been reaffirmed by the UN General Assembly at least 10 times by consensus. And what that means is that it was done without a vote. And so we can say safely today that no state in the world presently opposes the United Nations Declaration on the Rights of Indigenous Peoples. That's what it means. Last December, the UN General Assembly highlighted that declaration, and I quote, has positively influenced the drafting of several constitutions and statutes at the national and local levels and contributed to the progressive development of international and national legal frameworks and policies, end of quote. So the UN Declaration affirms, as Professor Gunn mentioned, a wide range of economic, social, cultural, political, spiritual, and environmental rights. These rights are inherent, or as we say, pre-existing. So it is urgent for Canada to finally respect and implement those rights in federal legislation. I'm pleased that Bill C-15, the UN Declaration on the Rights of Indigenous Peoples Act, is based on my own private member's bill C-262 and goes further, as a matter of fact, in certain instances. In my countless meetings and conferences across Canada, Bill C-262 received the widespread support from Indigenous peoples and the general public. It wasn't easy tabling a private member's bill. My first bill on the UN Declaration 641 was tabled in December 2014. It was defeated on second reading in April of 2015. In April 2016, I tabled a new and stronger Bill C-262. The House of Commons passed the bill at third reading on May 30th, 2018. However, a filibuster by a few senators killed the bill in June of 2019, just a couple of days before the passing of my mom. Therefore, I fully support C-15 being tabled by the federal government in the House in early December 2020. Government bills can proceed more efficiently, I believe, before the House and the Senate. Bill C-15 confirms the declaration as minimum standards for the survival, dignity, and well-being of Indigenous peoples. I would add security to that list, and must be implemented in Canada. That is what preambular paragraph 2 says. As a survivor of Indian residential schools, I'm especially pleased that C-15 acknowledges in its preamble the calls to action of the Truth and Reconciliation Commission and the calls for justice by the National Inquiry into the missing and murdered Indigenous women and girls, both of which call for the implementation of the UN Declaration. In reviewing Bill C-15, it is important to underline that its 17 preambular paragraphs have significant legal effects. They add important content to the 7 operative provisions in the bill, and they must be fully considered. For example, doctrines of superiority, preamble paragraph 9, which includes discovery and terra nullius, are condemned as racist and legally invalid. All forms of colonialism, preamble paragraph 10, are also rejected, and the government of Canada is committed to advancing relations based on such principles as justice, equality, non-discrimination, and respect for human rights. In preamble paragraph 11, the preamble emphasizes the urgent need to respect and promote the inherent rights of Indigenous peoples. The Supreme Court of Canada has also affirmed our inherent and pre-existing rights in Section 35 of the Constitution of 1982. In preamble paragraph 12, Bill C-15 adds that the Government of Canada recognizes that all relations with Indigenous peoples must be based on the recognition and implementation of the inherent right to self-determination, including the inherent right to self-government. As indicated in the two international human rights covenants, Canada has an affirmative obligation to recognize and respect our right to self-determination. This obligation has existed, as you know, Mr. Speaker, since 1976, when Canada ratified the two international covenants. In my introductory remarks, I would also like to emphasize two current problems with the current text of C-15. First, in some instances, the English and the French versions are not compatible, and this is a problem that must be immediately redressed. A second problem is in Section 4 of the Act. As currently drafted, it erroneously conflates two distinct and separate purposes as a single purpose that appears to solely relate to the action plan. This is patently incorrect. It would not be consistent with Bill C-262. Section 4 should therefore read, the purposes of this act are A and B. So I think I will end. I think my time is up, but I'm looking forward to the questions from the members of the committee. Thank you, Mr. Chair.
Thanks so much, Mr. Saganash. Cheryl Lightfoot is professor at UBC, appearing as an individual, and you have 6 minutes. Please go ahead.
Thank you very much, Mr. Chair. Good morning to those of us on the West Coast, and good afternoon to those of you further east. I want to open by acknowledging the lands of the Algonquin people, where the hearing is physically being held, and then also the lands of the Musqueam people, where I have the privilege to work and live, and where I am currently sitting, joining you virtually this morning. I'm Anishinaabe from the Lake Superior Band of Ojibwe. I'm Canada Research Chair and Professor of Global Indigenous Rights and Politics at the University of British Columbia. I had the honor to appear before this committee 3 years ago in April 2018 when Bill C-262 was being debated here in Parliament. And then, along with many other First Nations scholars, advocates, and community members, I, of course, was deeply disappointed by the failure to pass that bill into law. But I'm very pleased to be with you here today in hopes that Parliament can soon correct this historic failure and pass Bill C-15. And I want to thank you for the invitation to appear today. International human rights instruments like the UN Declaration are developed, of course, with the intention that they will be implemented in domestic contexts and in full. In legal human rights scholarship, there is often talk about rights ritualism. And in short, this means that states say one thing in the international arena, the human rights arena, and then do something else at home. In my own academic work as a political scientist, I've observed a pattern that I have referred to as selective endorsement. And what this means is that some states have attempted to water down the rights in the UN Declaration, accepting only some of them for implementation and then self-selecting out of other rights. And this is simply not morally acceptable to pick and choose human rights that one will respect while others are left behind. And I want to point out that rights ritualism and selective endorsement as phenomena are not limited to any one government or any one political party. Governments of all political stripes have repeatedly broken their promises to Indigenous peoples. Treaties have been violated, and Supreme Court judgments are at times reinterpreted and occasionally ignored, all the while portraying Canada as a global model for democracy and human rights. And of course, many out there wonder if Canada is really serious about reconciliation. And I've heard some very frustrated Indigenous people say reconciliation is dead. But what are we to do? Do we give up, or do we continue to try to find better tools? I'm strongly in favor of the implementation model that Romeo Saganash created when he first brought forward Bill C-641 and then Bill C-262 to Parliament. This model, which is the foundation for Bill C-15, has a number of elements that I think are crucial. First of all, it requires collaboration with Indigenous peoples. It also requires concrete action, including legal reform, and has been discussed, the creation of an action plan. And it requires public reporting and accountabilities. A large part of my own scholarly work involves looking at the comparative experiences of Indigenous peoples around the world. And I feel that Bill C-15 is advancing the global conversation and setting a very positive example for other states. When we look around the world, we can see that a number of states have undertaken legal and policy measures to implement the declaration. And as has been mentioned in the first hour, committee members have heard about the National Action Plan process being developed in New Zealand, for example. In addition, several countries in Africa have also implemented national legislation and policies to operationalize their commitments to the declaration. Constitutional reforms have also been an essential step, and Latin America has been especially proactive in this area. National courts from Belize to Botswana, Canada, Chile, Colombia, Guatemala, Kenya, Mexico, and the Russian Federation have all cited the declaration in legal decisions nationally. National human rights institutions in countries like Indonesia, Malaysia, Namibia, Russian Federation, and the United States have used the declaration as a framework for monitoring the implementation of Indigenous peoples' rights at the national level. The declaration is also being implemented regionally, and examples here include the European Union and the Organization of American States, the African Commission, and the African Court on Human and People's Rights. The Inter-American Court of Human Rights has also drawn substantially from the UN Declaration. And for more than a decade now, the Declaration has been used to set guidelines and standards on the international level. And a number of organizations have developed policies and/or guidelines to align with it. For example, and my colleague Professor Gunn mentioned some of these as well, the UN Development Program, the World Bank, the Inter-American and Asian Development Banks, and UNESCO. Various UN agencies and programs have addressed Indigenous peoples' rights as they relate to business practices and commercial activity as well. And international treaty bodies, the conventions that were signed, are also increasingly utilizing the UN Declaration in their assessments of compliance, therefore making the Declaration legally binding through those treaties. Quite simply, Bill C-15 represents the best approach to human rights implementation that I have seen from around the world, bringing all of these various elements together. Passing C-15 into law will set a genuinely positive example for the rest of the world community. And I know that other governments and Indigenous peoples in other regions of the world are watching this process very closely. Last week, my colleague Joshua Nichols from the University of Alberta and I published an opinion piece about the unfinished business of reconciliation. The Supreme Court has recognized reconciliation as a constitutional imperative. And as Professor Nichols and I wrote, the court meant something much more profound and challenging than simply trying to get along. Reconciliation is about putting inherent rights and title into meaningful practice. As we said in the article, up to this point, governments in Canada have left this work almost exclusively to the courts, and this has been a mistake.
Ms. Lightfoot, we're well over time, and we need to get all of our questioning rounds.
I'll just close with one sentence, if that's all right.
Go ahead.
If Canada is serious about reconciliation, we need a different approach. The Declaration is the right foundation, and Bill C-15 provides a clear, sensible process to bring these commitments to life.
Thank you very much. Thank you. And now to complete our panel, President and Chief Lorraine Augustine, on behalf of the Congress of Aboriginal Peoples. Ms. Augustine, please go ahead for 6 minutes.
Thank you, Mr. Chair. Can everyone hear me okay? Okay, perfect. First of all, I just want to tell you a little bit about the Congress of Aboriginal Peoples. I'm sure some of you know, but we're one of the 5 national organizations that has been around for over 50 years. We represent the off-reserve, non-status, and status Métis, and the Southern Inuit. So just to give you an idea of where our organization is coming from. Although I think that the UNDRIP, the Declaration, is definitely something that I support as an Indigenous woman, or as an Indigenous person, and as an Indigenous leader. The issue that I have, though, is that we are not looking at Indigenous, and I'm talking from the preamble of the bill, specifically with the interpretation of Indigenous people, being that definition of the Constitution of Canada, which says Aboriginal peoples is Indian, Inuit, and Métis. Unfortunately, I find that Canada has adopted a distinction-based, which takes in First Nations, Inuit, and Métis, and is used quite often in documents, in legislation. And First Nations is, in my view, not a legal term. My issue is that we need, if Canada is going to adopt this legislation, then we need to be sure that when they talk about Indigenous peoples, it means all Indigenous peoples, because the Declaration does not determine if you're Indigenous on reserve, if you're Indigenous off reserve, if you're status, if you're not status. It talks about Indigenous peoples in this country. So when you look back, and I looked at the convention, and right in the beginning of the convention, they condemn colonialism and all practices of segregation and discrimination associated in whatever form and wherever they exist. So right off the bat, even at the convention on the elimination of all forms of racial discrimination, by not including all Indigenous peoples within Canada, how can a piece of legislation be law when right off the bat they are leaving out the vast majority of Indigenous peoples who do not have a status, who do not live on a reserve? How can you say you're working with all Indigenous peoples? And I just want to quote something from the UNDRIP. In Article 2, it says, Indigenous peoples and individuals are free and equal to all other peoples and individuals, and they have a right to be free from any kind of discrimination in the exercise of their rights, in particular, that based on their Indigenous origin or identity. So, reading that, my concern is that already this piece of legislation is not being practiced. Canada did adopt it at the United Nations. I participated at the United Nations. And as a matter of fact, I was at the Constitutional Talks back in 1982. So I've been around for a little while. So my biggest concern, I totally agree with the intent of and what the United Nations has done. It's a very good document. But my concern is with Canada is the way it's written, the way the preamble is, it's leaving out 80% of the Indigenous peoples in Canada. So when we're talking about that, that is my concern with this preamble and with this piece of legislation. If you're going to put something through, then it talks about Indigenous, then it needs to be all Indigenous peoples within this country and not a selected few. And I'm talking selected in terms of the Indian Act registration. So that's where I am at, and I want to thank you for letting me speak and to address the committee. I do appreciate it, and I will answer any questions that you may have, and I look forward to the questions.
Thanks very much, Ms. Augustine. Much appreciated. I'm going to ask for a motion to extend our first round of questioning will take us past the hour. So I need a motion to extend with the whole, thank you, moved by Mr. Schmale. That's carried. That will allow us to get a full 2 panels of questioning in. And the next panel is, the next questioner I have will be Mr. Viersen for 6 minutes. Arnold, please go ahead.
Thank you, Madam or Mr. Chair. I want to really thank you and the witnesses for being here today. We are in front of dealing with a bill that's actually quite a short bill. I have it up on my screen here. It does not take very long to scroll through it. It's about, I think if you print it off, it's maybe 2 pages long, and then with a schedule that is just an entire readout of the UN Declaration. So the crux of the bill, I think, in my opinion, is just around Section 4A. That's probably the crux of it, is that the purpose of this act is to affirm the Declaration as a universal international human rights instrument with application in Canadian law. That's probably the meat of the bill, and then the second part is to establish the framework for the implementation. I guess I would just want to cycle through each of the witnesses. Do they support the bill in its current form? Kind of a yes or no on that there. Mr. Saganash? Yeah, he's giving me the thumbs up there. There are other witnesses as well. Ms. Augustine?
Not as it's written at this time.
Okay. And our third witness as well. Just trying to find you on the screen here.
Oh,
Lightfoot.
yes.
Ms. Lightfoot. Yes.
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 Yes. Thank you. I do support it, although I have heard similar calls to Ms. Augustine for some amendments, and I think through conversations and through the purpose of these discussions and these committees, that can be sorted out. And so I think it's important to listen to, and even Mr. Saganash had a few points that needed clarification and resolution. So I think that's the purpose of this committee. But generally, yes, I'm in support.
Okay. Ms. Lightfoot, sticking with you, what would be one of the recommendations for an amendment that you would put forward?
I'm going to leave that to the process because I think that's where you need to hear from the stakeholders, the rights holders themselves, like Ms. Augustine has stated, and let them bring forward their suggestions because I am not actually a rights holder in Canada. So I want to point that out. I'm not going to speak for those who are.
Yeah. So, but the bill is very like I read out. So one of the concerns, and maybe I'll go to Mr. Saganash with this one as well, to just explain how the declaration as being applicable in Canadian law, how that improves our current jurisprudence, I guess, and it improves upon the hard-fought battles that have been, or hard-fought and won battles in terms of the court decisions. And do we not risk undermining some of those court decisions by now introducing an entirely new system of law into Canada?
In fact, let me say this from the outset. The courts have already confirmed that provision that you read to us. The courts are using the UN Declaration, referencing the UN Declaration to interpret domestic law. And that's been going on for many years. Our human rights tribunals, provincial and federal, have been using the UN Declaration, even before it was adopted by the UN General Assembly. So what this Bill C-15 does, it just confirms what the courts have been saying and the interpretation and how courts have been using international human rights instruments like the UN Declaration on the Rights of Indigenous Peoples. What this bill will add, in my view, is that, as a member of Parliament, that the Minister of Justice has an obligation under 4.1 of the Department of Justice Act to make sure that any legislation, before it is introduced, is consistent with the Charter of Rights and Freedoms. We don't have the equivalent for Aboriginal rights and treaty rights in this country. Bill C-15 will provide that.
Just on that point, Mr. Saganash, around, like if I Google C-15 UNDRIP, the very first thing that comes up is the APTN article around like concerns around consultations on C-15, right? And that's the challenge that we are going to have as we bring in this as the application in Canadian law. What's the body that governs the Aboriginal opinion in this country, the Indigenous opinion, right? That's going to be the big challenge.
Well, Arnold, I think before responding to that question, I want your interpretation of what consultation is or consists of. Please define that for me, because
I would say that the right to consultation, the need for consultation, that's been clarified by the courts. We've got a brief from the electrical suppliers of the country outlining how over the last 7 years they've dramatically improved their consultation process to ensure that they're abiding by the court decisions. That's the worry around this, is like, does this not introduce an entirely new system,
Okay, I'm sorry to interrupt. I'm going to hold the thought. I'm sure that it'll get.
Those are very short minutes, Mr. Chair.
Well, I'm sorry, but we have timelines to work through. So hold that thought. Gary and Asangri, you have 6 minutes.
Thank you, Mr. Chair. And first off, let me begin by acknowledging that I'm speaking to you from the unceded lands of the Algonquin people in Ottawa. And I want to thank the panel and particularly my good friend, Romeo Saganash. We dearly miss him in Parliament, and I know he's not that far away when we need to reach him. So thank you, Romeo, for your enormous leadership. And of course, I was able to witness your work around 262 from the time you introduced it to the time it passed the House, and the enormous work that you put into it. So I want to thank you for that, and of course the work leading up to it with the development of UNDRIP. I want to just get a sense from you, Romeo, about the type of engagement you did leading up to 262. I know when we traveled as a committee, you were in this committee before, and when we traveled to many parts of Canada, people would come up and say, you know, Romeo, you came here this summer, you talked to us. So you had extensive engagements throughout the process of 262. Can you just maybe give us a sense of how deep that was throughout the time that you were developing this bill?
Well, first of all, Bill C-262 is pretty, C-15 is pretty much similar to 262. And I think the engagement that we've done around C-262 was pretty much thorough throughout the country. I've met with Indigenous and non-Indigenous communities in town halls to explain Bill C-262, to explain what the UN Declaration is all about, and answer questions or concerns that people may have had at the time about Bill C-262. And I can tell you that throughout my travels across the country, I did not leave one town hall, whether Indigenous or non-Indigenous, where people were opposed to Bill C-262 or the UN Declaration. So that work, I think, is a legacy going forward with Bill C-15. We calculated that among the Indigenous organizations and communities that adopted resolutions of support for Bill C-262 represented approximately 1 million Indigenous individuals in this country. So it's been extensive, it's been comprehensive, that engagement. And I think that is a legacy that we can take moving forward with Bill C-15.
Thank you, Romeo. Ms. Lightfoot, if you can maybe comment on the implementation of the BC UNDRIP in BC, and many of the concerns I think that are raised by some opposition would lead to believe that UNDRIP has basically implementation of UNDRIP in BC has severely affected movement of business there. Can you maybe comment on how it was implemented in BC and the relative success or unsuccess that you see in its implementation?
Yeah, thanks for the question. And I just have to point out that bill passed in late 2019, only a few months before the pandemic began. And so I would say implementation here in British Columbia is still at a very early stage. We are still waiting on the action plan, but that has been a bit disrupted by the pandemic and the conditions, especially in Indigenous communities in the province. The province did table its first annual report, which you can Google and find online. It is substantive, and so there are plenty of good news stories to report out of British Columbia. Of course, there are some bad news stories to report out of British Columbia as well. And to my mind, this is a normal part of a political conversation in a political context, is there will be successes and there will be failures. And it's our responsibility to sort through those. It's important to note that those successes and those failures do coexist simultaneously. And I also want to point out out, it is quite normal if we look across the country for there to be policy successes, policy failures on any issue, and also contestation. This is a normal element of politics and any sort of political decision making. And so to address the earlier comment as well about what is the Indigenous opinion on any of these issues across the country, well, it's as diverse as the non-Indigenous opinion on any political topic. So I just would like to bring that norm and what we understand as normal in everyday politics extends to Indigenous peoples as well.
Thank you. Just back to Romeo, I know one of the conversations we had throughout 262 was the issue of veto, and the same type of concerns are raised here. Does C-15 represent a veto with respect to FPIC, and maybe you can comment on your position as you had outlined previously?
Just about a half a minute. Sorry, go ahead.
You're on mute.
30 seconds. Okay. I commented on that extensively. Both veto and FPIC are two different legal concepts. One is absolute, and that is veto, whereas the other one is relative, like all human rights. The right to free, prior, and informed consent is relative. We have to take into consideration a lot of other factors, facts, the law, and circumstances of a given situation. So it's two very different legal concepts. So it's the FPIC that we're talking about. And I did send to the clerk yesterday the study that the expert mechanism on the rights of Indigenous peoples did on FPIC. And if I recall, paragraph 20 of that study done by the UN describes the constituent factors or constituent elements of free, prior, and informed consent. I invite all members of this committee to look into that.
Thanks very much, Mr. Saganash. Madam Beyroubi, 6 minutes. Please go ahead.
It's Ms. Gill who will be taking the floor, Chairman. Ms. Gill. Oh, no, don't mention it, please. Thank you, Chair. Thank you to my colleagues, and thank you, Mr. Saganash. He did so much during the previous Parliament, as Ms. Lightfoot and Ms. Augustine also have worked for so long, and one since 1982. So, Mr. Saganash, I know that there are differences between the two bills, between C-15 and C-262. You might be able to address this qualitatively as to the differences that exist between the two bills. Do you have any comments that would help us along? Well, thank you for your question. Glenn, it's always a pleasure to see you again, and thank you for the work that you do as well on behalf of the Bloc Québécois on this issue. I mentioned in my introductory remarks that there were differences between the French version and the English version of Bill C-15. Well, a good example of this is the following: 2.2. 2.2. When you talk about, when you read the English version,
of the Constitution Act 82, and
in no way abrogates or derogates from that. Yet, when you read the French version, the current version maintains the rights of Indigenous peoples recognized in the 1982 legislation, and in no way attacks it. There is a difference in the English and the French. In a sense, I prefer the French version, which is much clearer in terms of intent as to the provisions of Bill C-15. I think that that's an excellent intervention, because we work on the bills, and if the French version and English version are it's a problem, because the meaning has to be the same in both English and in French. So I think that should be taken into consideration as of now, and for all the witnesses that will be appearing on the bill. I want now, I've listened to the response. Madame Augustine and Ms. Lightfoot talked about the evolution of the legislation. We are looking to, we have a bill that is intended to, in a sense, implement what is in UNDRIP. And we don't want to have a bill that dilutes these rights that are set out in UNDRIP. Could you comment on that? Maybe whether or not it's Ms. Lightfoot or or Ms. Augustine to answer my question, or Mr. Saganash.
Tackle that question, if you don't mind. The other panelists can as well. But when it comes to the piece of legislation, again, we are still left out because of the distinction-based approach from the government. It's very specific in what they look at under Section 35 of the rights. According to the way things are now, I'm a registered Mi'kmaq, I'm status. I don't, because of where I chose to live, they're telling myself as well as other members of my organization and constituency of the Congress, we are not rights bearers. So my concern is with this piece of legislation, if they're going to be leaving out, which the piece of legislation reaffirms that Indigenous peoples have rights. They have treaty rights, they have Aboriginal rights, they have other rights. So I'm really not for this unless this government makes it available and talks about all Indigenous peoples. And right now that is not happening. I'm not sure if that answered your question or not, Madame.
Yes, you've given me a great deal more information that is going to allow me to improve the work that I do as a legislator. Thank you. But I don't know if the other witnesses want to say anything about the same subject, or if not, I have another question.
We're 2 seconds left. And
déjà.
I'm sorry about that. But it's nice to see the camaraderie. Yes, go ahead.
One of the differences between the British Columbia bill and this bill also was the inclusion of Indigenous governing bodies in British Columbia as part of the legislation. So I would just like to table that as something to be considered.
Thank you for that. And Ms. Blaney, go ahead, please, for 6 minutes.
Well, thank you, Chair, and thank you to all the members here for your testimony. If I could start with you first, Mr. Saganash, it's very nice to see you again. As a jurist, I know you understand the difference between FPIC and a veto. I'm just wondering if you could explain, with your legal understanding, the difference to the committee.
Well, as I mentioned earlier, I did send a copy of the study that the UN did on the concept of free, prior, and informed consent. I invite all members of this committee to review that document. I think it's an important document for your consideration, especially considering Bill C-15. Free basically means no coercion or intimidation. For instance, I can give you the example of Site C Dam, where BC Hydro intimidated the opponents of the project with lawsuits of $4.3 million each per individual. That's called intimidation. You're not allowed to do that. No coercion, no intimidation. That's what FREE stands for. Prior means that these discussions, this engagement with Indigenous peoples that may be impacted by a project, they need to happen prior to any decision taken about a project. That's prior. And informed means that we need to have access to studies and information that is readily accessible to the people that you represent. For instance, for a long time, Hydro-Quebec provided the CRE with studies about the impacts of their projects on my people, but solely in French, not in English, not in Cree. So we cannot be informed if that's how things are going to happen. So all of these three steps need to happen prior to embarking on a specific activity. And that's how Thierry Redon, I read his paper, who testified in the first hour, talks about this. I read his paper, and it's consistent with what the UN has been saying about free, prior, and informed consent. Like all human rights, the right to free, prior, and informed consent is a relative right. You need to take into consideration other factors, whereas a veto is an absolute concept that doesn't take into consideration the law or the facts or circumstances of a given case.
Thank you. The committee recently received a letter from the Confederacy of Treaty 6 First Nations, Romeo, basically cautioning that Bill C-15 will have an effect of changing the definition of Indigenous persons as defined in international law. Can you speak to this important matter, and has the UN ever adopted a definition of Indigenous peoples?
Well, that's a good question and an important question, I believe. I can say this firmly, that there's no, to my knowledge, no UN body that has adopted a definition for Indigenous peoples. The only definition I'm aware of was a 1972 working definition by Martinez Cobo, who did a study, an important study, a 5-volume study given to the UN in 1978, I believe, in 5 volumes. But the working definition back then, in 1972, was never adopted by the Working Group on Indigenous Population or by any UN body. In fact, I can also add that the 2 international covenants that I spoke about, signed on by Canada in 1976, the Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, both in their Articles 1 talk about the rights of all peoples, the right of all peoples to self-determination. Well, in international law, the term peoples was never defined. There is no definition for peoples either. So I think it's important to be aware of that, because once you decide to define something, then you end up excluding others. So I think that's the reason, the main reason behind the UN not adopting a definition for Indigenous peoples.
So another concern raised by opponents of Bill C-15 relates to the claim that Bill C-15 domesticates or canonizes the United Nations Declaration on the Rights of Indigenous Peoples. Do you agree with this assertion?
Absolutely not. It doesn't. I think the bill just confirms, Bill C-15 just confirms that this international human rights instrument, like all other international human rights instruments, have application in Canadian law, in a sense that any court, in their impartiality, any court can refer to this international document to interpret domestic law. So it's the opposite. It's the opposite. I think it's from a domestic perspective that we need to consider these other documents to interpret what the rights are in this country. So
Thanks,
it serves in that sense.
Thanks, Mr. Saganash. Madam Gill, do you have a point of order? I see your hand up.
Yes, Mr. Chair, I was wondering. When he said that the bill was not the same in the English and French versions, I wondered which of the two versions should have precedence the way it is drafted now, and should there be a motion tabled, or should there be something that I should table to have it the same in both languages?
To continue on with the round of questionings, and we'll close with that point of business. Okay, and that brings us to Mr. Vidal. I'm sorry. No. Jamie Schmiel. I'm on the wrong page. Jamie, you have 5 minutes. We're in this next round of questioning.
I'm glad you just didn't forget my name. I'm glad you just weren't looking at the wrong spot. Appreciate that. Good to see so many familiar faces again. Great conversation so far. Maybe I might start with Miss Augustine, if I could. I noticed in your opening statement there was a brief mention about the consultation process, how many organizations, some were given lots of times to consult and think and come back with responses, and other organizations were not. Did you want to expand on that a bit?
Absolutely, and thank you for that question. Other organizations, and again, it goes back to the distinction base of First Nations, Inuit, and Métis, which are three national organizations, were given at least 6 months of preparation, consultation. The Congress of Aboriginal Peoples was given 2 days prior to it going to here. So Department of Justice contacted us at the 11th hour of the 11th day to give our input. Our input was given. We weren't going to refuse because, they contacted us and obviously we're going to be there. So that's the difference in the consultation process where other groups, and again, I'm going back to the distinction base of, and it's even in the bill about the interpretation. Canada is the only country that is interpreting its Indigenous peoples, which is wrong. Indigenous peoples are Indigenous peoples, and it shouldn't be a distinct base. So the consultation process, we were discriminated there too. We never got the same opportunity as other groups.
Thank you. I think that was one of the things we mentioned too when we were discussing the work plan for this, is the fact that there are groups that are raising their hand and saying, yeah, we don't, or we haven't had the appropriate time to prepare and consult. And that's one of the reasons why I think this study is so important, and your contribution to this conversation here, the ability to give testimony to the committee, and hopefully we can make some recommendations. Is there anything else you want to add, Ms. Augustine? In terms of maybe talk about the action plan going forward or something like that? I think you touched on that in your statement.
I did. I think it's a great idea to have a national action plan, but again, I think it has to be inclusiveness. Canada has always had 5 national organizations. The Congress has always been a part, way back when it was the Native Council of Canada, NCC. We were always at the table. We were always part of it, and now we're not. And that since this last government seems to be even more. There is we need to have a national plan that's going to incorporate all Indigenous peoples, whether it's by organization, whether it's by peoples, but we need to have a say in all. And I just very quickly just want to give you a quick example. The missing and murdered Indigenous women, they have a national core working group to work on a national plan. It's been nothing but trouble. You have one organization saying this, you have another saying that. It's not supposed to be political on that end. It's supposed to be everyone working together. So national action plans and getting everyone at the table is going to stall a lot of the progress in terms of where we're going. And I've seen that firsthand.
Chair, how much time do we have?
You have 2 more minutes.
Two more
I'm
minutes.
sorry, no, I'm sorry. 1 more minute. This is 5-minute round. 1 minute.
I'll take the 2 though. Thank you. No. Maybe I just want to talk about what we discussed in the first round regarding just to build on what you talked about, but also regarding the fact that we still haven't dealt with some major issues, including the consent part. And I think just for those on this panel that may not have been watching or listening on the first panel, we do support the spirit of the document. I think it's a document that has a meaningful path forward. But one of the part on this side of the aisle we're having troubles with is we want to see the definition of consent. What does that mean before this goes forward? I don't know if you have any comments on that.
Are you asking me?
I can move it around the room if you want.
Doesn't matter. No.
Okay, I'll start with you and then move it to the rest of the room.
Very briefly, go ahead.
Okay, very quickly. I think that, yeah, it does need to have a little bit more. The consent has to be consent with everyone, all Indigenous peoples, on reserve officer status, non-status.
Thanks. Thank you for that. And that brings us to another 5-minute round with Mr. Baptiste. Go ahead.
Thank you. And I'd like to start off asking a question to Romeo Saganash. And Romeo, I just want to start off by acknowledging your work on this. And getting it to where it is right now, I just want to say how deeply I appreciate your work over the years on this. As you know, my father and Grand Captain of the Mi'kmaq Nation, Alec Denny, for years were going to the United Nations trying to implement Indigenous self-determination. And you noted earlier that UNDRIP and C-15 are the minimum standards, and rights like Section 35 are talking about pre-existing inherent rights. And in the preamble, it speaks to the urgent need. The preamble of UNDRIP talks to the urgent need to respect and promote inherent rights of Indigenous people. Why is it an important point to know that these are pre-existing inherent rights in your comments earlier?
Sorry, I think it's important to re-emphasize that point. When we say that our rights are inherent or pre-existing, it's because it means that no one has given us those rights. We possess them as Indigenous people and Indigenous peoples. So what this bill does is to recognize and affirm that very essential and fundamental fact that all of these rights, all of the rights that UNDRIP enshrines, are inherent and pre-existing. And that is the very reason why courts have been using the UN Declaration to interpret Aboriginal rights here and abroad. There are specific countries that were mentioned. In Colombia, in Guatemala, in Belize, courts have interpreted Indigenous rights in those countries based on what the content of the UN Declaration was. And yet these countries do not have a C-15 legislation that confirms that UNDRIP has application in their national law. So I think that is an important aspect of all in this discussion. And that includes, of course, the right to self-determination and the right to free, prior, and informed consent. These are human rights. And we're in 2021. And I think it's grand time that all politicians, all members of parliament, stand up and recognize and uphold those human rights of Indigenous peoples, of the first peoples in this country.
Now, there's been a lot of questioning on whether the UNDRIP creates new rights, and there's a lot of people creating fear that this UNDRIP is going to create new rights. Do you see this as reaffirming the pre-existing rights and inherent rights of human beings, Indigenous people in Canada, or do you see this as creating new rights?
It does not, and for a long time, the chairperson of the Working Group on Indigenous Populations, every session of negotiations, she would repeat, this declaration does not create new rights. It just confirms the inherent rights of Indigenous peoples, the pre-existing rights of Indigenous peoples. So I think it's this is a question that is not relevant in my mind, because both the Bill C-15 and the UN Declaration both reaffirm that these are pre-existing and inherent rights.
Thank you, Romeo. And I thought your analysis of the whole citizenship question and identity was spot on in your earlier segment. And I want to read off before I go to Miss Augustine on her comments. In Article 33, it says of UNDRIP, Indigenous people have the right to determine their own identity or membership in accordance with their customs and traditions. This does not impair the right of Indigenous individuals to obtain citizenship of the states in which they live. Ms. Augustine, you've quoted Section 35 of the Constitution, but are you in disagreement with Article 33 that Indigenous people should have the right themselves to determine who their membership is?
Absolutely not. I don't disagree with that. What I disagree with is that I should be able to say to anyone, I'm a Mi'kmaq woman, and I don't need, because of my affiliation with a different organization or with a band, that I'm not an Indigenous woman.
But you would agree with the UNDRIP Section 33 that it's for Indigenous people, it's for the Mi'kmaq people to decide who's Mi'kmaq, not an outside entity, as clearly stated in Article 33. Do you agree with that?
Well, to a degree, yes, but as you're
which part of that you don't agree with?
I agree with it. What I don't agree with it is that the Mi'kmaq, and Jamie, you're from my same area, so you know this, that the Mi'kmaq are determining who a Mi'kmaq is, but they're still leaving out those who either don't live on a reserve or those who don't or cannot be registered.
Okay, I'll interrupt it. I'm sorry to interrupt there. Sure. We'll go to Madame Bérubé, I believe. Will you take the next question, Madame Bérubé? For 2.5 minutes, and then Ms. Blaney for 2.5 minutes.
Merci, Monsieur le Président. Thank you, Chair. Thank you. Thank you to all our witnesses who are with us today. My question is going to be for Mr. Saganash. I'm very glad to see you again. I'm very happy to see you. I'd like you to describe the notion of self-determination and consent in the Canadian context. Well, on this point, and this is a very important point, it's something that has to be taken into consideration when it comes to C-15. What you have to understand in this debate is there is a different legal framework that applies to Indigenous peoples. Section 35 of the Constitution is a very significant one, but you have another one. The treaties are also a very important legal framework, and international law is another important legal framework. Also, Indigenous law is important. We have our own laws. So these 4 legal frameworks are different, separate, but strengthen each other mutually, and they are interlinked. And they can be used by Indigenous people to defend their inherent rights or their treaty rights.
Mute.
Muted.
Excusez-moi.
Oh, I'm sorry. So in Bill C-15, does it require really free, prior, and informed consent? I missed the first part of your question. Can you repeat it, please? I wondered whether, in your opinion, Bill C-15, as it stands now, should give a clear, specific definition of free, prior, and informed consent. To my mind, no, I don't think so. Because the way in which the legal system operates leads to a decision or a legal consideration will depend on the circumstances of the law and the facts that define a specific situation. So if you define this, you would eliminate a whole bunch of other situations. So really, it's up to the judges, to the courts, that should take into consideration the different circumstances and the law that applies according to the circumstance.
I'm sorry, Mr. Clerk, before we get to Ms. Blaney, what is our time consideration with regard to translation and technical support?
There is another committee scheduled in this room for 3:30 p.m. So we will have to wrap up soon. Probably 2 p.m. as a hard stop.
Okay.
Chair, I also have an SO31 I have to get to the House for, so I'll have to leave very shortly as well.
Okay, so could I just ask Ms. Blaney to complete the round of questioning and then we'll adjourn? Are we good with that?
Yeah, because I'll have to, otherwise you can continue, I just have to go.
Okay, we're going to do it that way then. And Ms. Blaney, go ahead for 2.5 minutes.
Thank you, Chair. Romeo, if I can come back to you, there have been some concerns raised about Section 2.2, the non-derogation clause, that would maintain the status quo in respect to the doctrines of discovery and the notion of terra nullius that have been used against Indigenous peoples. Is that your understanding of this clause?
Yeah, I've heard the concerns, but it is not my interpretation of Section 2.2 or 2.2. It's the opposite, I think. If you read carefully the first phrase of 2.2, it says this act is to be construed as upholding the rights of Indigenous peoples recognized and affirmed by Section 35. So I think that's pretty clear for me. That's a safeguard of the rights that we have presently as Indigenous peoples in this country, and not the contrary. With respect to the other concerns, with respect to terra nullius or the doctrine of discovery, I think those are rejected pretty firmly, pretty clearly in the preambular paragraphs. I think the only thing that's missing in 2.2, in my view, to clarify my point, is the fact that we need to add what the Supreme Court of Canada said with respect to Aboriginal rights and treaty rights that are not frozen in time, that they must continue to evolve. I would add a Section 2.4 after 2.3 that basically says the rights of Indigenous peoples, including treaty rights, must be interpreted flexibly so as to permit their evolution over time. And any approach constituting frozen rights must be rejected. The Supreme Court of Canada in Sparrow said
I'm not prepared to address it right now. Gary,
sorry, Mr. Chair, I thought you did address it, saying that it will be part of the amendment. So if there are issues that do come up, I think we can definitely address it through the amendments, and we look forward to receiving that. Mr. Saganash, Romeo, and Madam Gill will work with you to ensure that the spirit and intent of the legislation is reflected in both official languages.
I believe that was contained in my answer to Ms. Gill. So with
Chair,
that, yes.
Mr. Chair, would it be possible to ask a very quick question for Mr. Saganash?
I'm sorry. We technically have to be out of the room.
I wanted to take Mr. Melillo's place if he didn't have a question.
Well, I'm sorry. As the chair, I'm going to thank our witnesses and
thank you, Mr. Saganash, for being here and for all your hard work. It's great to see you.
And you can offer a motion to adjourn, Ms. Zan, if you'd like. Thank you.
Unfortunately and sadly, I will offer.
That's carried.
A motion.
The meeting is adjourned. Thank you.
Thank you.